My colleague Aman Sharma is also joining us with more on this. Aman, what's curious to note here is that the CBI is now saying they're going to appeal the suspension of the sentence, which was precisely on this aspect that he cannot be considered a public servant. But in the past, they have actually backed that argument, legally speaking.
Well, Shivani, yes, now the CBI is saying that it's going to challenge this judgment in the Supreme Court with a special leave petition. Also, they are saying that it is the CBI which secured a conviction in the first place in the trial court, despite all that is being said against the CBI. It also says that it vehemently protested the bail or the suspension of the sentence of Mr. Sengar while arguing in High Court. But the documents here, the court judgment itself of the High Court, the victim's family is raising strong questions on the CBI. Look at the first argument where the court, when it says that Mr. Sengar can't be considered a public servant under POCSO, the special public prosecutor of the CBI tells the court that yes, even though it's been held by the apex court in an earlier case that an MLA is not a public servant as defined under section 21 IPC, it is for the courts to adopt the principle of purposive construction. So the CBI there in a way admitting before the court that yes, there is a judgment earlier of the Supreme Court which says he cannot be considered a public servant, but can you do something about it by the way of purposive criticism? Obviously, this did not cut any ice with the court. Then I would like to point to you a paragraph from number 16 of the High Court judgment, in which the court is saying that the learned trial court, it is quoting from the trial court's observations, that it is an inescapable in conclusion that the IO of the CBI did not conduct a fair investigation in the matter, resulting in a disadvantage to the case of the victim and her family members. This is also very striking comment by coming in the court judgment. Then the victim tells the High Court that even after the investigation was transferred to the CBI, fairness and impartiality were not ensured. The most damning, I would say, towards the end of the judgment, in para number 40, the High Court is noting that the learned counsel for the victim has drawn the attention of this court to a catena of points which have been highlighted in the earlier judgments to contend that the investigation was faulty and the appellant, who was in a position of authority, has bent the law to his advantage, and a premier institution like the CBI has been compromised in the nature and manner of collecting evidence. I think what the High Court pointed out to the 2019 trial court order, in fact, has been very important in the judgment. In 2019, the victim's family may be realizing that the POCSO charges on public servant may not stand. They wanted graver charges of the IPC to be put on the Mr. Sengar, because saying that, he is in a position of power, he's an MLA. So the IPC stiffer provisions should apply to him, which would ensure life imprisonment. In that particular application, the High Court has noted that the CBI did not support that petition. In fact, the CBI said no more charges are required. This is what has been also been noted by the High Court in its judgment, that the order passed by the trial court in which it dismissed the petition of the family to put graver charges of IPC, it was not supported by the CBI, the petition of the family. So all these things together raising question marks over how the CBI has also handled the case. And yes, though they secured a conviction, but when it came to the High Court, this particular defense that the CBI was putting, that Mr. Sengar is a public servant under the POCSO Act, that simply has collapsed, and that is why the CBI now has to go to the Supreme Court to make its case there before the Supreme Court bench.
Well, tricky issue here, whether the graver section does apply to him or not, or whether the CBI could have done more. In fact, when I spoke to the survivor's lawyer, Mahmood Paracha, he also made the charge that the CBI has been hand in gloves in ensuring that Sengar gets this suspension of sentence. I spoke to him about the setback that they have received as far as the suspension is concerned and what can be done next. Here he is expressing his views on what happened with this order. Are you saying the CBI is at fault here? Are you making that charge?
100%. They were hand in glove. They've made their 100% effort to get him acquitted. But despite that, so much evidence had come that the court could not give a finding other than his conviction. That is the real story. The central government is trying to withdraw. They have actually placed best of the lawyers, costliest of lawyers, best of lawyers in Supreme Court to have the security withdrawn from the girl as well as from the family. They were successful in getting the security withdrawn. But we had to fight tooth and nail to even maintain the security of the survivor. But in the best effort of the central government and state government is to put them under so much pressure that you will be killed, otherwise compromise. Okay. And interestingly, I will tell you one more interesting fact. For the first time, one lawyer in the High Court, appearing from CBI, was trying to do his job honestly to some extent. to some extent, not entirely. He was not allowed to continue in this case. So do I need to say anything more? Nothing has been said about this aspect in the judgment.
Do you think that this is a sort of a small victory for you, that finally the Central Bureau of Investigation has gone ahead and decided to file this entire application in front of the Supreme Court?
It is a one-step victory, I would say, because we have a long way to go, and the way she has suffered and the way things have been manipulated since beginning, I think we are in a way satisfied, but still apprehensive till the time it is not filed. And even if it is filed, what is the next step? Like what Supreme Court decides is the main factor.
Delhi High Court was of the opinion suddenly that Kuldeep Singh Sengar was not a public servant. How do you see this? He was still an MLA. So what were the arguments that you think might have gone ahead, or what was the exact issue that might have?
So how does that matter to the rape? I mean, the crime itself is so grave, and when the government says they are serious about बेटी को बचाओ, बेटी को पढ़ाओ, अब की बार ये सरकार बहुत हुआ नारी परिवार. And does that matter if he is a politician or if he is not a politician, if he is a public servant, not a public servant? He can't get away with the crime. The crime is same and the law is same for everyone.
You met the leader of opposition Rahul Gandhi yesterday. What is the future plan of action? Are you seeking time from the Prime Minister or the Home Minister as well?
We have been asking time from them. We've been writing to them and we've been asking, this girl has been asking that I want to meet because she needs some ray of hope. Till yesterday her husband was suicidal and I was trying to do counselling personally. She was suicidal. I think after meeting one prominent leader of the country, they found little solace and I think they found little motivation that yes, there are people with them, the powerful people, as she wanted to meet. So we went ahead.
During the course of this entire matter, in the High Court, in the trial court, raises big questions upon the CBI.